I'm Brittany Lewis with Forbes Breaking News. Senator John Cornyn discussed the bipartisan gun deal unveiled over the weekend. The proposal includes strengthening background checks and boosting red flag laws. The Texas Republicans said that while the group of lawmakers made headway in the text of the legislation, they have, quote, run into a couple of bumps in the road. Listen in as Cornyn explains.
Mr. President, on Sunday, a bipartisan group of senators announced principles for addressing the concerns over shootings like occurred in Uvalde, Texas 3 weeks ago, and other places as well. And I would say we've been making good progress, but we've run into a couple of bumps in the road that have slowed things down a little bit. One of them is over crisis intervention programs, something we agree is very important. I believe that we ought to put every state in a position of seeking and receiving funds for crisis intervention programs that they have in place already, even if they don't have a red flag law. Red flag has been what's been discussed many times, but 19 states have red flag laws, but that means 31 states have other crisis intervention initiatives that are designed to address the same problem, which is people who are a danger to themselves and others because of their mental health. It includes things like assisted outpatient treatment programs, drug courts, mental health courts, and veterans courts. The other issue that we are wrestling with relates to the domestic violence provision and the way non-traditional relationships are handled. We need to define this in a very crystal clear way. It can't be overly broad or open to interpretation. It needs to be something that can actually be applied because we're talking about very serious consequences here. Of course, with both of these provisions, we must include rigorous due process protections. That's a red line for folks on my side of the aisle. I know Senator Schumer, the majority leader, wants to put this bill on the floor next week. But unless we can resolve these differences over these two provisions and do it soon, hopefully today, then we won't have time to prepare the text so senators can read the bill for themselves, which we would expect them to do. And so that's going to require some continued work and good faith negotiations on all sides. The details of these provisions are critical for support from my colleagues on this side of the aisle, and I hope that our colleagues across the aisle will understand if we continue down this path without resolution that we're jeopardizing the timetable that the majority leader has set out for us, or we're jeopardizing the likelihood we can get to 60 votes for anything. And we know how hard this is. I'm eager to wrap up our negotiations, but we're not going to cut corners or capitulate for the sole purpose of passing something. I'm not willing to compromise on some of my basic principles or throw the Constitution out the window so we can have something we can hold up and say, look what we did. There's a bipartisan appetite to get this done. That's good. And I'm optimistic about how far we've come. But we're not there yet. And we need to continue and do so quickly to reach an agreement on language so we can then write the text and have the vote. From the outset, I said I wanted to identify targeted reforms that could have prevented the recent tragedies in Uvalde and elsewhere. That includes stronger mental health resources, which could have helped Salvador Ramos before he became so sick that he killed innocent children and he committed suicide essentially in the process. That includes school safety measures, which could have prevented the shooter from actually getting inside Robb Elementary School. And it includes reforms to prevent violence by criminals and other dangerous individuals. The National Instant Criminal Background Check System is one of the most effective tools we have to keep guns out of the hands of criminals and people who suffer from severe mental illness. But it's not a perfect system. It's only as good as the information contained in the system. For example, in 2017, the shooting at Sutherland Springs, a little town outside of San Antonio, Texas, my hometown, what happened there highlighted the gaping hole in the background check system. Despite the fact that the shooter had a long and disturbing history of violence that should have prohibited him from purchasing a gun, he was able to do so because the Air Force, in this instance, had not uploaded his felony convictions, his domestic violence conviction, nor his mental health commitment. In response to Sutherland Springs, Senator Murphy and I introduced the Fix NICS Act to ensure that all federal agencies accurately and correctly upload the required conviction records on a timely basis. Yes, this is the same Senator Chris Murphy who I'm working with now to try to achieve a success here. We've done it before, and I believe we can do it again. Our bill was signed into law in March of 2018, and in the first 3 years, 11.5 million more records were uploaded into the 3 national databases that the FBI checks. The number of records in one of those databases increased by more than 30% alone. So I think I can say with assurance that what we did together in 2018 has saved lives. Because if it kept a gun out of the hands of somebody who is already prohibited from getting a gun under current law, we will have saved a life, maybe even the life of the shooter. 60% of the gun deaths in America are suicides. But I know we've saved at least those lives, and I think many others as well. But as the Uvalde shooting demonstrated, there's another hole in the background check system, and that is juvenile records. Salvador Ramos showed up at the age of 18 and had a clean record as far as the background check system was concerned because it couldn't look back at his troubled history, struggling with mental health and law enforcement problems. So he showed up as if he had been born the day before and nothing else previously mattered because it wasn't in the background check system. If there were disqualifying criminal or mental health records, that information should show up in the NICS system. In other words, if there are things in your life that would disqualify you if you were an adult, but that happened before you turned 18, I think that's the information we need and would want to have for purposes of determining who should be able to purchase or possess a firearm. So that wall that prevents the look back into pre-18-year-old records is obviously a problem. 4 years ago, the Uvalde Police Department received information about 2 male juveniles, 13 and 14 years old, who were plotting a school shooting for their senior year. That's 4 years ago, and they were plotting a school shooting when they graduated in, you guessed it, 2022. Now, there's no way for us to know for sure whether one of those individuals was Salvador Ramos because those juvenile records are not available to us. But I'm here to say that if it's not Salvador Ramos, then we have even a bigger problem. If there are 2 additional young 13 and 14-year-old boys out there saying they're going to shoot up a school when they become seniors, we have even a bigger problem. One of the provisions we're discussing would encourage the states to upload similar relevant juvenile records into the NICS. This is standard practice in some, but not all states, and it's easy to see why it's important. If an 18-year-old is convicted of aggravated assault, a felony, the record will show up in his background check and prohibit him from purchasing a gun. But if a 17-year-old is convicted of the same crime, the record will not necessarily be uploaded into the National Instant Criminal Background Check system. If he tries to purchase a gun at 18, the background check's likely to come back clean. Again, because the system is only as good as the information in it. But let me give you another example. An individual could be adjudicated mentally ill on his 17th birthday and actually be civilly committed for multiple months in a mental institution. But that same person could likely purchase a gun at the age 18 without anything showing up on his record. Existing law prohibits that purchase, but not all the states are sending us that information to the National Instant Criminal Background Check system. That's why, or those are examples why, it's so important to be able to get that look back and their pre-18-year-old history for mental health or criminal justice encounters. This is not actually an expansion of the background check system because it doesn't add any new restrictions to gun ownership, but it would permit the background check system to actually have access to relevant and material information. It's a common sense step to ensure that the data in the NICS system is accurate. That's easy enough to say, but we need to ensure this idea would work in practice, and that's exactly what we're examining now. Number one, we need to ensure this provision would protect due process of law. That's a constitutional right. That's fundamental. Under current law, anyone who receives a denial has the right to appeal that decision or challenge the accuracy of the record. And of course, those same protections should exist for juvenile records as well. Secondly, we need to establish an interim plan while these records are being uploaded into the background check system, a process that will take some time. Now, my colleagues across the aisle suggested a mandatory waiting period for all purchasers under the age of 21, but we didn't agree to that. There's no reason why somebody who passes a background check with all relevant information in the database should be denied the ability to purchase a gun. In fact, we're talking again about a constitutional right. So no mandatory waiting periods. But we are looking at extending the investigatory period for juvenile records that are unclear or ambiguous. Let me explain what I'm talking about. Under current law, a person who wants to purchase a gun from their local retailer must complete a background check. We talked about that. In nearly 90% of the cases, the background check is resolved almost immediately because these are computerized records. The average processing time is, in fact, less than 2 minutes. In those cases, the seller receives an immediate answer. Either the sale can proceed or it cannot. In the remaining roughly 10% of background checks, the system doesn't return a green light or a red light. In short, this happens where there are question marks or other things that need to be inquired about. This could be caused by a number of factors. If the buyer has a common name, the system could pull records for the wrong individual with the same name. It could also be caused by incomplete criminal history records. For example, if somebody was convicted of an assault, but the record doesn't say whether it was a felony or misdemeanor, or in some cases, whether the assault was a domestic violence incident, that would have consequences in terms of their ability to purchase a firearm. So further review, further investigation sometimes is necessary to see whether the light should be green or the light should be red. Under the current law, the FBI has up to 3 business days to complete a background check and give the seller a clean answer on whether the sale can proceed. That's current law, up to 3 days. In many cases, this review that we're talking about adding for persons between 18 and 21, this review can clarify that a sale can proceed. And that's a great thing. That's how we safeguard Second Amendment rights for law-abiding gun owners. We've discussed the idea of extending that investigatory period when there's a question mark surrounding juvenile records. Again, this is the exception to the rule where more information is required because the answer that you get is ambiguous or unclear. But under this enhanced review, an 18-year-old with a clean record would be able to expeditiously purchase a firearm. The extended investigation period would only apply to those rare cases, and again, for only those 18 to 20 in which the system does not return a clear answer, yes or no, green or red, but rather a yellow light. We believe that this is a common sense and straightforward way to improve the existing background check system without adding new restrictions. As I said, Mr. President, negotiations are ongoing, but time is of the essence because we need to get to agreement so we can get text to our colleagues so that the majority leader can bring this bill up on the floor next week after giving everyone a chance to read it and understand it and have their questions answered. Mr. President, I yield the floor.